For the record, beginning of file number 1, Congressman Overeem.
Would you raise your right hand, please? Do you solemnly swear the testimony you're going to give in this deposition is the truth, whole truth, and nothing but the truth, so be it?
Yes, ma'am.
Thank you.
Morning, Mr. Klein.
Morning, Mr. Durrell.
How are you?
I'm good.
We've met before.
Yes.
Have you ever testified in a deposition before?
Yes.
Okay, that's what I thought. But we're going to go through a few little things. First of all, I've already forgotten to have you state your name for the record.
Philip Klein, spelled P-H-I-L-I-P, last name Klein, K-L-E-I-N.
That was one L in Philip.
Yes.
How are you employed?
I'm president of Klein Investments Incorporated, as well as president of PRK Enterprises Incorporated.
Do you own or are you an officer of any other companies besides the two you just mentioned?
There are some sub-corporations in Klein Investments, and I serve on the board of directors of Texas Professional Bodyguards, LLC.
Okay, why did you say sub-corporation? I don't know what that means.
Klein Investments Incorporated owns a company called Texas Professional Bodyguards, LLC.
So if we looked at the right documents, we would find there is no owner of that company except Klein Investments. Is that right?
No. I have a business partner. His name's Richard Corriega out of San Antonio, Texas.
And I'm sorry, would you say the name of the LLC again?
Texas Professional Bodyguards, LLC.
And is Texas Professional Bodyguards currently active in business?
It is.
Any other companies that you would be involved with as an owner or senior manager besides the two you've just given the names of?
PRK Enterprises has one sub-corporation called Klein & Associates Political Relations. It's more of a, how would I classify it? It's more of a DBA.
So it's just an assumed name of the first company. It's not a separate
PRK
company.
Enterprises Incorporated.
Yes, let me rephrase. I'd be more specific. It's just an assumed name of PRK Enterprises Incorporated.
Yes.
It's not a separate company.
No.
That's correct.
That's correct. Yeah.
It's a double
Negative question.
This is an official proceeding under Rule 199 of the Texas Rules of Civil Procedure. Do you understand?
Yes.
You and I have had casual or informal conversations from time to time over the years. This will not be one of those. Do you understand?
Yes.
You have sworn an oath to tell the truth today, and this is an official proceeding under Rule 199. Do you understand?
Yes.
Because this is an official proceeding and you have sworn to tell the truth, anything you say that's later proven to be false will subject you to the penalties of aggravated perjury, which are 2 to 10 years in the penitentiary and a fine of up to $15,000. Do you understand?
Yes.
Do you plan to tell me the truth today?
Yes.
Who is Stephen Hartman?
Mr. Hartman is an ex-employee of Klein Investments Incorporated, DBA Klein Investigations and Consulting.
Was Mr. Hartman an employee of Klein Investigations on October 13th, 2016?
I don't recall the date actually, but if I recall correctly, he was an employee in October of 2016. I can testify to that.
All right. I'm giving you that date because that is the date of an incident that's now become the subject of this lawsuit.
Okay.
All right. You're familiar with the incident where Stephen Hartman pointed a gun at two women out of a car and was subsequently arrested, prosecuted, and criminally convicted, are you not?
That's how it was reported to me, yes.
Did you testify at Mr. Hartman's trial?
No.
Did you attend Mr. Hartman's trial?
No.
What lawyer represented Mr. Hartman in the criminal case?
If I remember correctly, I think John Morgan did.
And Mr. Morgan's also represented you in matters from time to time over the years, right?
Yes.
Did Mr. Hartman's employment status with Klein Investigations change after the October 13th, 2016 incident?
If the date, October 13th, is when it happened, yes, it did.
I will, thank you. I will represent to you that I believe that is the date that it happened. If I happen to be wrong about that, what I'm going to try to refer to as the incident, or the October 13th incident, is the incident we described a moment ago involving the pointing of a gun at the plaintiff, Litisha Peshoff, as she drove her car, and Mr. Hartman's arrest and later trial and conviction of the crime of deadly conduct.
Yes, sir.
Okay, so I'm not trying to trick you with the date. If I'm wrong about that date, we're still talking about that incident.
Yes, sir.
All right, you were about to tell me that Mr. Hartman's employment status with Klein Investigations changed after the October 13th, 2016 incident.
Yes.
And how did it change?
He was terminated.
Who terminated him?
I did.
Why did you terminate him?
To the best of my recollection, he was working off the grid, which in our context means that he was working outside the course and scope of his employment.
Okay. How was he working outside the course and scope of his employment?
It was reported to me that Mr. Hartman had been placed under arrest for pointing a weapon at a female on Twin City Highway. Mr. Hartman was interviewed the next morning. He admitted that he did pull a weapon. We asked him for the case number. There was no case number assigned. There was no we have certain steps we do before we take somebody into custody. There was no background done, no verification of warrant. There was nothing done. We had no idea who the subject was. We had no idea of the paper issued. We had no idea of what was going on.
All right. There was a lot to unpack there, so let me go back and do my best to address some of those things more clearly. You said you were told that Mr. Hartman was arrested. Who told you?
I first learned that Mr. Hartman was in custody the night before my meeting with Mr. Hartman. I was at a...
Sorry to interrupt, but that was the night of the incident, right?
The night of the incident,
You
yes.
learned of it almost immediately.
Yes.
And my question was, how did you learn of it?
I learned about it through Mr. Hartman's wife, who contacted me on my cell phone. I then called the Port Arthur Police Department, talked to a detective who checked in on it for me, and then I learned that what the charge was, which was deadly conduct.
Who was the detective you talked to?
You know, I want to say it was Scott Gaspard, but I don't really recall. I think it was Scott Gaspard, to the best of my recollection. It's been 3 years ago, so I really don't remember, but I think it was Scott Gaspard.
And he is or was at the time with?
Port Arthur Police Department, Detective Division.
What is Mr. Hartman's wife's name?
I don't remember, Mr.
Okay.
Dunn.
As a result of Mr. Hartman's wife's telephone call and then your telephone conversation with someone at Port Arthur Police Department, you then summoned Mr. Hartman to a meeting the next morning. Is that what I'm hearing?
No, the next phone call I made was to Klein-Gear in our office, to see what file they were even talking about. She advised to me that there was no file with that name, there was no number assigned, there was nothing. We had no idea what was going on. So then at that point, I said that we'll just have to work it all out and get him in the office the next morning and find out what happened.
And how was that arranged?
He just showed up at 10 o'clock in the morning.
So you didn't ask to meet with him, he just showed up?
Yep,
Because he was your employee?
yep.
And he thought he still worked for you, I guess?
That would be a good assumption, yes.
And he did work for you at that time, when he showed up that day?
When he showed up at 10 o'clock in the morning, he was employed with the company.
What is the normal process by which someone in your office undertakes a bounty hunting job?
So it's like any other case. The paper is given to us by whatever agency or bail bond company. It goes to Ms. Gear. Ms. Gear does a background on the subject, confirms with the Sheriff's Department the warrant. Then a file is made and assigned a number. For example, if it's January 1st of 2019, it gets the number 0101 and then whatever the next up number is. So in that case, it would be like 1001 as an example.
Okay.
Once it's assigned a number, it's put into our CAD system, a CAD system, with all of the information on the subject. Everything's scanned in and put in a PDF. And then the case is assigned by Ms. Gear to whatever investigator is up. What we technically do is we assign the cases to the next person up. We try to make it even for everybody to have an even amount of cases.
Okay. How many people have you got today that you're assigning these bounty hunting cases to?
We don't do any more bounty hunting.
Okay. When's the last time you did any?
I don't recall.
Is there some reason that you stopped doing that business?
Probably because we got busy with larger cases, such as Child Rescue Network cases that we have to travel a lot or we have to be out of town a lot, and they're complicated cases.
All right. Klein Investigations had a contract with Al Reed Bail Bonds to do bounty hunting, did it not?
It did.
And this was not on a per case basis. Let me rephrase that. The payment for these was not on a per case basis, is that right?
If I recall correctly, we received a stipend, $1,500 a month, to pay our cost of gas, travel, whatever the ancillary costs were, and then for service, I believe there was another fee if I remember correctly, but I really don't remember that contract right now sitting here.
What is the word you just used? It sounded like incendiary costs?
Yeah, such as like travel, if we have to stay overnight in a hotel, you know, just our base expenses that we have.
Okay, I've never heard that word before. Can you spell it?
I know.
Okay.
Can't spell it.
All right.
I'm not a very good speller.
I did remember that. Sorry. How long I'm now talking about Klein Investigations. How long did Klein Investigations have a contract with Al Reed Bail Bonds for bounty hunting for?
A year,
And it was just that 1 year.
yes.
And the contract was not renewed.
It was not renewed.
Can you tell me how many bounty hunting cases you would have done for Al Reed Bail Bonds pursuant to that contract that I think was in effect in the year 2016?
I can't put a number on it. I don't know sitting here today.
Can you give me any kind of a ballpark idea? Was it more than 1,000, less than 10?
I hate to put a number on it, but just guessing, probably over 100.
Okay.
But that's a guess.
I understand.
Ballpark guess.
I understand. Is there some document that would list off all of these Al Reed bail bond bounty hunting cases so we would know exactly what the number was?
Possibly I'd have to check with Ms. Gear. She's in charge of all the documents and that sort of thing.
So whatever the number of cases was, your testimony is that each time Al Reed wanted Klein Investigations to do a bounty hunting job, you would go through the set of procedures you were describing a few minutes ago.
Yes, and Ms. Gear is the coordinator, and Ms. Gear would receive the warrant, and Ms. Gear would receive the habeas, and Ms. Gear would receive the instructions, and I guess they call it their background sheet. And that Al Reed was
Who's there? Who's they? Al Reed?
Yes,
Ms. Gear is your daughter, is that right?
she is.
And she's also an employee of Klein Investigations.
She is.
Did she testify in Stephen Hartman's criminal trial that resulted from this October 13th, 2016 incident?
She did not.
Okay. Did anyone associated with Klein Investigations testify in Mr. Hartman's criminal trial?
To the best of my knowledge, no.
Did Klein Investigations produce any documents that were requested by the district attorney in the criminal prosecution of Mr. Hartman arising from the October 13th, 2016 incident?
No.
Was Klein Investigations ever requested to produce documents that it did not produce?
No.
How do you think it was possible, or do you know how Mr. Hartman was able to, I'm going to call it freelance, on the Peshoff, Chakowski matter that resulted in the October 13th, 2016 arrest?
I have no idea, and I was just as surprised as everybody else.
You personally investigated this after you
I
found...
did.
I'm appreciating your enthusiasm to answer. Let me finish the question so our transcript has a complete question, and then we have your answer. I'm going to ask that again. If I can remember what it was. Can you help me?
Do you know how it was, Mr.?
That's what it was. Thank you. Thank you. You personally investigated the incident after you learned of it.
I did.
And that investigation consisted of one meeting with Mr. Hartman?
Yes.
I guess we could include your conversation with the Port Arthur Police Department Detective Division.
Yes.
What else?
That's it.
Okay. Did you...
Other than the morning when he came in.
Well, that's the one meeting I was talking
Yeah,
about.
okay, I'm sorry. Yes.
There were no other meetings.
No other meetings.
And if the timeline is right, that would have been on October 14th, 2016.
I don't remember the day, but I do remember the incident.
If the incident was October 13th, the meeting we're talking about would have been October 14th.
Yes.
And how many days was it until you terminated Mr. Hartman's employment?
Mr. Hartman was placed on suspension on the day of the meeting, and we began to investigate immediately regarding the warrant, regarding if there had been any background check done, regarding if the habeas was confirmed, and we found that there was no communication to the Sheriff's Department, there was no communication to Ms. Gear, there was no file pulled, there was no number pulled, so...
Can I stop you for a minute?
Go ahead.
What does it mean when you say file pulled?
Ms. Gear pulls a file, remember, Ms. Gear pulls a file and puts a number on it, and that is assigned a case number. And then Ms. Gear's responsibility is to check into the background of the warrant, to check in to see if the warrant is still active, because there are some times where warrants are not active, and then to assign it out. So the first person I interviewed was Ms. Gear, and I asked her, do you know anything about this? And she said, I have no idea who that is. I have no idea of that case number.
So would it be accurate for me to think of pulling a file as creating one?
Yes.
Okay. So in every one of these 100 or so, if that's the right number, cases that Klein Investigations did for Al Reed, there we would find a file.
Absolutely.
Okay. There was never, your testimony is there would never have been a bounty hunting job worked for Al Reed without the formalities of creating a file and assigning a number unless it was being done behind your back.
Absolutely.
Okay. Did you discover that any other such bounty hunting incidents were done, I'll say again, freelancing or behind your back?
No, that was the first one that we found.
What was the second one you found?
Because we had one.
Okay, so there's one and only one.
To the best of my knowledge, yes.
You've investigated it since then to look for that?
We investigated it at the time when we were doing Mr. Hartman's investigation. When I placed him under suspension, Mr. Hartman was very upset, and I just advised him he needed to leave the office, turn in his passcode to the doors, and he needed to leave the property, and then we would get back to him as soon as our investigation was complete.
You were probably a little angry at Mr. Hartman when you discovered that he was working behind your back, weren't you?
I don't believe the word anger is appropriate. I think confused. Mr. Hartman been a long-time employee. And,
How long?
8, 9 years, to the best of my recollection.
And this is the only incident that ever involved aggression by Mr. Hartman or an arrest or prosecution of Mr. Hartman while he was in your employ?
No, he was arrested one other time when he was attempting to serve your client, Lane Walker, and he was attempting to serve him with some type of paperwork, which he was subsequently released from.
What does released from mean?
The case was dismissed.
What case?
He was arrested for and I don't know.
Forgive me for interrupting. I'm a bit lost in your pronouns. Does he mean Mr. Hartman?
Mr. Hartman, yes,
Okay.
I'm sorry.
Hartman was arrested and charged with something as a result of
Interference of court, I'm sorry, go ahead.
Thank you. Hartman was arrested while attempting to serve process on Lane Walker while he was presiding on the bench in his courtroom. Is that right?
Yes.
What was he arrested for?
To the best of my recollection, interference in a court proceeding. I've never heard of it before, but to the best of my recollection, that's what it was.
Could it be disruption?
It could.
Could it be disruption by noise?
It could.
Okay. Did it concern you after that? By the way, when was that incident with with the attempt at service of Judge Walker?
I can't remember the exact date.
Would you disagree if I told you I thought it was May of 2013?
Again, I don't know the date.
You filed a lawsuit against Judge Walker, did you not?
I did.
Was it related to that incident?
If I believe so, yes.
Okay. But you still don't remember when the incident was, not even the year?
No.
What happened to your lawsuit?
I think it was eventually dismissed.
How many times did you file it?
I don't recall. That would have to be work on the attorneys.
Okay. Did it create any concern in you that Mr. Hartman was disruptive in Judge Walker's courtroom while he was on the bench attempting to serve him and got arrested for it?
No, there was a videotape. Mr. Hartman was wearing a body camera, and the entire incident was recorded on videotape that eventually led to a warrant for, I think, 2 or 3 deputies and I think Judge Walker himself.
Was anybody else ever convicted of any crime as a result of the attempt to serve Judge Walker?
To the best of my knowledge, no.
Has anyone ever been found liable for any damages as a result of the attempt to serve Judge Walker?
I don't know. My understanding is the case continues, and I don't keep up with it. I don't have time for that.
So you said Mr. Hartman was wearing a body camera. Can you describe a body camera for us?
In this case, it was a pen camera.
Also sometimes called a pen recorder.
Could be.
Does it look like a pen?
Yeah, it does.
So it's about this size,
Yeah. Okay. Well, maybe a little bigger.
maybe a little bigger, but it's intended to be concealed.
Yeah.
Yeah,
It could be concealed or overt or covert.
Was it concealed in this case while it was making the recording?
I don't know where he had it on his body. Going back in my memory of looking at the video, I think he had it in his top right pocket.
Were you present at the courtroom when the attempt to serve Judge Walker on the bench occurred?
I was not.
Were you present just outside the courtroom when the...
I was not.
Let me finish the question. Were you present just outside the courtroom or elsewhere in the courthouse when Mr. Hartman attempted to serve Judge Walker as he presided over his court?
I was not. I was at my office in a conference call.
Okay. Is it legal to record videos of proceedings in a courtroom in Jefferson County?
You don't need to answer that question. That's not relevant to why we're here today. Do you understand my instruction?
Yes, sir.
Okay. Well, it's very unusual for an attorney to instruct a witness not to answer a question. So when your attorney does that, I have to go through a little protocol to make a record because you're the one that ultimately is responsible for it. Are you going to follow your attorney's instruction not to answer the question I just asked?
Absolutely.
You're refusing to answer,
I'm following my attorney's advice.
which was to refuse to answer. Is that right, sir?
I'm not going to answer.
And the basis for refusing to answer is that the question is not relevant. Is that right?
That would be an attorney question.
Well, I'm asking you, Mr. Klein.
I'm not a lawyer.
That wasn't my question.
My attorney has asked me not to answer the question. I will not answer the question.
Okay. What did he just say was the reason for instructing you not to answer?
I'll say it again. It's not relevant to any issue that we're here to discuss. It won't lead to admission of admissible evidence, and it's providing a legal opinion that the witness has not been designated to provide.
Are you aware, Mr. Klein, that refusing to answer my questions in this deposition may be treated by the court as your failure to appear today and can subject you to various penalties, including payment of my client's attorney's fees if we have to seek a motion to compel your answers, to payment of the costs of another deposition, and even imprisonment? Are you aware of that, sir?
He doesn't need to answer that question either. He has an attorney. Anything I tell him is privileged. Don't answer that question.
I don't want you to answer any question about what any attorney has advised you. My question is, are you aware that your refusal to answer questions in this deposition may be treated as a failure to appear for this deposition and subject you to the pains and penalties of a contempt citation?
Again, don't answer that question.
Mr. Klein?
I'm instructing the witness not to answer the question. Do you understand my instruction?
Yes, sir, I understand.
Okay, and so now you're going to tell me what?
Go ahead and tell him you're not answering the question
I'm not
based on my
answering the
advice.
question. My counsel has advised me not to.
I forgot if you already answered this, but how many people did you have doing bounty hunting at the time that Mr. Hartman was doing it that led to the October 13th, 2016 incident?
2, 3.
And they were Mr. Hartman and who else?
Charley Klein, and I forget the other one's name. She's subsequently left the company. I can't remember her name right now.
Okay, I'm just going to take a wild guess. Charley Klein is your son.
It is.
All right. How long had your company been doing bounty hunting? How many years? For Al Reed or anybody else at the time you made the decision to focus your efforts somewhere else?
Since 1994.
So would I be correct to say from 1994 to roughly 2017?
That would be a good guess.
Okay. And besides the 3 people we just talked about, the one whose name you don't recall, your son Charley Klein, and the defendant, co-defendant, in this case Stephen Hartman, what other people did bounty hunting for your company in this 13-year period? Sorry about that. My fault.
I have personally made arrests.
And that's it?
Possibly some other ex-employees of the company were involved in arrest on warrants.
Is it accurate to say this was a relatively small portion of Klein Investigations' business in this 13-year period?
Absolutely.
All right. What kind of procedures did Klein Investigations have to train the people that you employed, Charley Klein and Stephen Hartman and the person whose name you don't recall, on the correct way to do bounty hunting?
The law is very specific, so there's legal classes that we teach internally, and then the actual procedure for arrests are done through their personal protection officer licenses out of Alamo Protective Services.
Okay, so my question was about training. You said legal classes internally. Who teaches those?
That is taught by myself as the senior manager for the company.
And how did you learn what the law was about bounty hunting?
As a certified manager under the Texas Department of Public Safety, we go through course training and then we must pass a test.
And were you telling me who administers the test?
Texas Department of Public Safety.
The DPS. Is it your testimony that Mr. Hartman completed the class and passed the test?
He did. He completed the class and passed the test, and his skills were done at Alamo Protective Services.
What does skills were done mean?
Where you learn how to use handcuffs, learn how to use self-defense techniques, learn how to use proper procedure post-arrest.
Say it again, Alamo Protection?
Alamo Protective Services.
Protective. Alamo Protective Services. Is it Inc.?
I believe. I don't know the
Okay.
proper legal acronyms.
Okay. So Alamo Protective Services would have taught Mr. Hartman on the use of a gun?
Yes, that would be correct.
What else?
Well, Alamo Protective Services teaches us personal protection officer techniques. It's a very extensive class on bodyguard operations. In that, they also teach how to arrest, how to handcuff an individual, certain defensive techniques. So I do not allow any private investigator to do any arrests unless they're at the PPO level.
The PPO level means personal protection
Officer level. That's the highest level in the Texas Department of Public Safety Private Security Board.
And when you say level, this means some recognition or certification by the DPS?
Yes, sir. It's called level 4. It's the highest level you can get.
And your company policy is that no one does bounty hunting unless they are at this highest level of personal protection officer.
Yes, sir.
And so from that, we can deduct that Mr. Hartman was at the highest level of personal protection officer.
Yes, sir.
What was it that you taught? Is it more than one class, or is it just one class that you have from time to time as needed?
So every 2 years our licenses come up, and we have to have a certain amount of CEs for all levels. So we go to CE classes that are taught either by the United States government or that are taught by the Texas Department of Public Safety or that are taught by a certified school. This includes handgun training. This includes any law changes from the previous biennium.
And in your previous answer, when you said CE, did that mean continuing education?
Yes.
What did it mean when you said in your previous answer that every 2 years your licenses come up?
We have to renew our licenses.
What happens if you don't renew?
I'm sorry?
What happens if you don't renew?
Your license is terminated with the state.
Is it terminated, or is it just suspended until you meet certain requirements?
No, it's terminated.
Okay.
You have a certain amount of time.
And what do you have to do to renew?
You have to go through your proper CE classes. I think it's like 20 hours, I think it is, of CE on certain different levels. And then you have to, of course, reapply with the state, have a background done, and, of course, pay your money.
You have to reapply.
You have to reapply.
And who certifies that someone has completed the required 20 hours of continuing education?
It's all done internally at DPS. You go to the class, you sign off in the classroom, and then they submit that to the Texas Department of Public Safety.
Okay. Are you able to tell us how many times Mr. Hartman renewed his license?
I don't have a number on that.
Okay. Are you able to tell us how long Mr. Hartman had the license at the time of the October 13th, 2016 incident?
I don't recall.
Can you tell me all of the reasons that you terminated Mr. Hartman's employment?
Post-investigation, we found that proper procedure was not undertaken. We found that Mr. Hartman had not only had not followed proper procedure, but that he lied to us during his initial interview post-incident. And that,
Can I just stop you there?
absolutely.
Because you said lied in the initial interview.
Mm-hmm.
If we are referring to the meeting you had with him the following day when he just showed up at the office,
Yes, sir.
my understanding was that that was the one and only meeting that you had with him.
Yes, sir.
Okay. So it's not an initial interview, it's the one and only meeting you ever had with Mr. Hartman.
I guess we could clarify it as saying initial and final interview.
Okay. I'll take that, which we already agreed was probably October 14th, 2016.
If that's the date, that's
If that's the date. And you say he lied to you during that meeting.
Yes, sir.
What did he lie about?
He lied about the how he obtained the warrant. He lied about making contact, I believe, if my memory is correct, with Ms. Gear. And he initially lied to me about why he pulled the weapon.
Okay. Have you now told me all of the reasons that you terminated Mr. Hartman's employment?
To the best of my recollection, yes. There
Okay.
may have been others. But,
Okay. Well, how would we know what others there might have been?
there was a termination report that was filled out, and a letter was sent to him advising him of his termination.
Okay. Would we be able to rely on the letter that you sent to Mr. Hartman terminating him as stating all of the reasons that his employment was terminated?
I would have to say yes.
Okay.
To the best of my recollection, yes. I think I put it all down on paper. I don't recall all the reasons right now, but that's...
Fair enough. Sorry, I think I interrupted you. You want to finish your
No,
thought?
it's just, it was 3 years ago, and, you know, a lot of things have happened in 3 years or 4 years.
Let me talk about these three lies and bear down a little bit more on it. In the meeting on or about October 14th, 2016, between you and Mr. Hartman, you said he lied about how the warrant was obtained.
Yes.
What was the lie?
He said that he got it on email, and we got into his email system, and we could not find it.
What is the truth, if you know?
That's the facts, that we didn't see it. And there was no reason for them to send him the warrant. Everything goes through Klein-Gear. And Al Reed knew that, and Al Reed's people would always send warrants to Klein-Gear.
Okay. He claimed to you in your meeting, the only meeting you ever had with him after the incident, right?
Yes.
He claimed to you that he received the warrant to arrest Gidget Noel Jakowski by email from Al Reed. Is that right?
If that's her name, yes.
We can say the person that he was attempting to arrest when he pulled the two women over in the car.
To the best of my recollection, yes. That's
Okay.
what he said when he walked in the door.
And your basis for saying that's a lie is that you could not find any such email.
We could not.
Okay. Did you ever do anything else to find out how Mr. Hartman got the warrant?
Well, we confronted him with that and said we can't find it in the email system, nor can we find it in the CAD, nor could we find it in Caroline's CAD. And then he started getting upset, yelling and screaming at me.
What is a CAD?
A computer-aided device.
Can we be any more specific?
Yeah, computer.
Okay. Sorry, I'm not good with initials and acronyms. All right. Now I'm confused about our chronology because I thought we had established there was only this one meeting on October 14th, and now you've just told us that you confronted Mr. Hartman about what you thought to be a lie and that he became upset. When was this confrontation?
At the same meeting.
Okay. So while Hartman is sitting there, you were able to go check computers and you find no emails.
Yes.
And was this done by you personally?
Done by me and Ms. Gear.
Okay. And when you didn't find the emails, you came back and said, I'm not finding any emails, or something to that effect.
Something to that effect.
And he became upset.
Irate.
Irate. How did you know he was irate?
because he was screaming at me.
Did you ever seen this conduct before?
One other time,
When?
when I believe, if my memory is correct, he was confronted about being out on a surveillance one night in the middle of the night, and we discovered that he really wasn't at the surveillance, and he became irate.
Would you describe Mr. Hartman as having an explosive temper?
No. I think when Steve feels like he's cornered or he's confronted with the opposite side of a story, sometimes he feels that he's being accused of lying, and I think that bothers him.
It bothers him to be accused of lying,
Yes.
but according to you, it apparently doesn't bother him to lie.
I can't answer that.
Well, you haven't seen any-
You're trying to put me in his mind. I can't.
And I should have said you haven't seen any evidence of that.
That one other time when he got irate.
And how long before October 14, 2016 was this other incident where Mr. Hartman became irate?
I'd hate to give you a date because I don't remember.
Don't give me a date. Was it 9 years, 6 months? How long, if you know?
It had been a long time
A
ago.
long time.
Yeah.
All right, you said that Mr. Hartman lied to you about contact with Ms. Gear. We're talking about Carolyn Gear, your daughter. Is
Yes.
that correct? By the way, a minute ago when you said Steve, you were referring to defendant Stephen Hartman in this lawsuit, correct?
Yes.
What was the lie about contact with Ms. Gear?
He had originally said when he walked in the door that he had advised Caroline that the warrant was there. Caroline adamantly got in his face and said, "No, you did not. This is the first time we're hearing of this. Where did you get this paper? Why didn't you go through proper channels? Why didn't you advise me so I could create the background on the subject and also confirm the warrant?" Because that's standard operational procedure in any case we do.
What was the answer?
He didn't have one.
So he just stood there while all these questions were being asked
Yes.
and then became irate.
Then became irate.
You said that Mr. Hartman lied about why he pulled the weapon on Ms. Peshoff and her passenger. Did I get that right?
That's true.
Okay. What was the lie?
He originally first said he had it at the stand ready
What
position.
does that mean?
When you pull your weapon in tactical operations, and he was trained as a tactical operator as a PPO, that when you pull your weapon without pointing at somebody, it's called the stand ready, which means it's across your chest or across your vest or whatever you're wearing at the time. And that's what he said he did. He took it at the stand ready. Subsequently, we learned, we pulled the arrest report as part of our investigation, and we found that he in fact got out of the car and pointed the gun.
Okay. Am I thinking of it correctly when you say stand ready, that the person is holding the gun and it's against their chest or vest?
Against their chest, yes,
Okay.
or vest, whatever
Or
they're
vest. All right. Can you demonstrate that for the camera?
wearing. Sure. Stand ready would be that you would pull your weapon, you bring it across, you would not have your finger on the trigger, and you would put it across your chest like this in a stand ready position. So meaning that you felt you could have been under attack or may be under attack. That's how we're trained.
Okay. Good. Thank you. That's very clear. And so the lie was that Mr. Hartman said the only thing he did was have his gun in the stand ready position.
Yes.
And when did you discover that that was a lie?
I think it was about a day or two later during the course and scope of my investigation. I think my investigation was like a day or two or maybe three when I read the police report and what the witnesses had said.
Okay, and what was the truth?
Truth was that he had gotten out of his car and had this weapon out of his holster and had pointed it towards the two young ladies. At least that was their side of the story.
Did Mr. Hartman point his gun at the two young ladies while they were both still in their cars traveling down a road?
According to one of the women, yes. The other women said she didn't see the weapon other than at the stand ready position.
While Mr. Hartman was still in his car? Is that right?
I don't recall. The best of my recollection is that he had it at the stand ready in the car, and when he got out of the car, according to the report, if my memory is correct, that he still had the gun in his hand, and his possibility he pointed at one of the women.
Okay. You believe the police report and testimony of witnesses that say that Mr. Hartman pointed the gun at the two women while he was driving in his car?
Doesn't matter if I believe Hartman or if I believe the two girls. He broke every company policy if he was working for me at the time, which I still believe he was not. He pulled his weapon without being threatened.
Nevertheless, my question is, do you believe the witnesses and the police report that say something different from what you say Mr. Hartman told you in your October 14th, 2016 meeting?
Yes.
Because you concluded that he was lying,
Yes.
which was one of the reasons you fired him.
Yes.
Okay. Is there anything else that has caused you to form an opinion about whether Mr. Hartman was being truthful with you during the October 14th, 2016 meeting?
Well, I had been through with Mr. Hartman before when he was cornered about a surveillance and how he reacted when he was confronted with, look, we know you weren't there, and how he reacted. So it was kind of the similar reaction. That's what kind of made me think.
Are you telling me there was another incident where he pulled a gun on somebody in a bounty hunting project?
No, I didn't say that.
Okay, that's what I thought. Please clarify for me.
If you'll go back to my previous testimony, he was confronted one time on a surveillance where he said he was on a surveillance and he really wasn't. And we confronted with him and he got upset. So it was the same reaction that I got before.
And by go back to your previous testimony, you're referring to what you said in this room a few minutes ago?
Yes.
Okay, there's not some other recorded testimony that I'm supposed to refer to?
No, other than he didn't follow the company policy.
Okay.
He wasn't in a company car, which would have recorded everything because we have a CAD system on there that records everything. He was in his private vehicle.
Okay. Anybody want a break?
I'm good.
I need a short one.
Sure.
Trying to palm it off on y'all, but if you're not going to take the bait, then I'm going to call for it myself.
Back on the record, beginning of file number 2, counts 11-12.
We're back on the record after a short break. Mr. Klein, I saw you had an opportunity to speak to your attorney during the break. Without telling me anything that you might have discussed with your attorney as a result of that conversation, do you wish to change any of the testimony you've given previously today?
No.
Okay. I'm looking at some responses that your attorney served us to requests for production. I seem to have only one copy of them. I'm going to hand this to counsel. What I'm wanting to ask him about is...
You only have one copy of it.
Great. Okay. Can you look at request for production number 1, your answer?
Just so that we finish the same thing. The one served on January 18th.
That's what it says.
Okay.
Looks like this.
Yes.
I'm sorry, repeat your question.
Yes, sir. I'm just trying to get you to the same page that I'm on, which was page 4 of the document whose title is Defendant Klein Investments, Inc.'s Objections and Responses to Plaintiff's First Requests for Production that were served to my office on January 18, 2019. I'm asking you to look at page 4 and the response to request for production number 1. Are you there?
Yes.
Okay. There is a legal objection. My question is about the response subject to the objection. I'm just going to read it, and you can read along with me if you like. Subject to and without waiving the foregoing objections, see attached documents, Bates numbered Klein 00001 to 00041 and 00050 to 00058 that will be produced upon entry of an appropriate protective order. My office does not have any record of having received these documents, although this response says they are attached. Do you know whether you produced these documents?
He did not. And I don't think it says they're attached. It says after an appropriate protective order has been entered, and no protective order has been entered
So see attached.
upon entry of an appropriate protective order.
Well, they were not attached. I can see the protective order language. It says that. This is what I'm confused, and this is why I'm trying to clear it up. And I figured out you didn't produce them because you wanted a protective order, but
sir.
this says attached, which makes me want to look for a document that was attached. And I think we've clarified now through your counsel's volunteered testimony and yours that these documents have not been produced. Would you agree with that?
I have no idea. I
Okay.
can't agree to that. I have no idea.
Are you able to, the request is for written employment policies, training, and practice manuals that Klein Investments would have been using on or about October 13th, 2016. Are you able to tell me whether any such documents exist?
I don't recall.
Do you have an employee handbook?
We do.
All right, so you have recalled that there's one document that would be responsive to this request.
Yeah, we do have an employee handbook.
Do you have policy guides?
That would be part of the employee handbook.
Do you have training manuals?
That's held by the Texas Department of Public Safety Private Security Board.
The training manuals, I don't understand held. The training manuals are not in your office?
No, they're updated frequently.
How are they distributed to employees?
We can get them online.
All right. Did you make any effort to do that to produce here?
I don't recall.
All right. But you've now recalled two different categories of documents that a minute ago you said you didn't recall. How about general orders and policies?
That would be in the handbook.
How about policies regarding weapons?
That would be in the handbook and also at Texas Department of Public Safety.
What do you mean by in the Texas Department of Public Safety?
I didn't say that. I said at the Texas Department of Public Safety,
Okay.
their manuals.
Which you would access online and distribute to your employees as you thought it was needed.
But they can do it online in their offices.
Okay. So you depend on the employees to do that then?
We send well, actually, I call everybody together and tell them there's been some updates to the training manuals. They need to get updated, usually after the biennium.
Does the biennium mean the
Legislative cycle.
Does the biennium mean the end of the biennial session of the Texas legislature?
Yes, sir.
And the reason for that is because there are sometimes changes to the law.
Yes, sir.
Do you do anything to make sure that the employees actually access and download the updated manuals?
Yes.
What do you do?
I personally check, go over it with them We have a training session.
Well, if you're going to have a training session and go over it with them, why is it necessary to tell them to download the document themselves?
Because I want them to be prepared for the meeting, so when I question them, they're prepared.
Can we go off the record for a second?
Sure, going off the record at 11:19.
What kind?
Back on the record at 11:22.
Back on the record, after a conference between counsel, the documents that were requested in plaintiff's first requests for production number 1, which I just read the response to and questioned the witness about. The plaintiff would like to have produced. Counsel for Mr. Klein's company has stated that he wants a protective order to prevent dissemination of these documents to people outside the lawsuit. I have said that I would agree to that. I don't know about counsel for any other parties, because if it's produced to one, it's produced to everyone. But I'm stating this as our agreement pursuant to Texas Rule of Civil Procedure 11, that counsel for Klein Investigations will follow up by sending me a proposed protective order to sign so that we can then get the documents that are described in this request. Mr. Hurst, do you have anything to add?
I do. Since this response was filed, as the response indicates, it was filed when I was with a firm called Hermes Law. Since that has happened, I have changed firms, and sitting here today, I don't know that I have the Bates stamped 1 through 41 in the file at Thompson Co. or 50 through 58. I will endeavor to find that out and provide that information to Mr. Durrell. If I do not have it, it simply could be in my file but not Bates stamped, and I will check with the client to see what documents these were and send you a proposed protective order as to these documents.
Thank you. The witness has described the documents to my satisfaction. So whether you have whatever was at one time Bates labeled or not, I want whatever he thinks is responsive to the request.
I agree.
Okay, thank you.
Subject to the entry of a protective order signed by the court. I agree, subject to that.
Any other counsel have any problem with an agreed protective order to prevent dissemination of the documents we're talking about outside of the parties and attorneys in this case?
No, whatever y'all agree to, I'll agree to.
Okay. Okay. Mr. Klein, I took some notes on your earlier testimony, which of course doesn't mean that they're correct, but as I understood your testimony, you testified earlier today that you terminated the employment of Stephen Hartman for several reasons. You mentioned that Mr. Hartman did not follow the proper procedure, that he lied to you in your meeting with him on or about October 14th, 2016, and we discussed the three things that he lied to you about. I believe you testified you thought that these were all of the reasons that you terminated Mr. Hartman's employment. Is that correct?
To the best of my recollection today, yes, 3 years later.
And you said that we could probably rely on the letter that you wrote to Mr. Hartman terminating him for a complete recitation.
Yes, I believe so.
All right. I'm handing you what's been marked as Exhibit Number 1. This is a document that is Bates marked Klein 00190, and it appears to be your letter to Mr. Hartman dated October 18th, 2016. Are you able to tell us whether this is what it appears to be?
Can you give me a minute to go over it, please?
Of course.
Thank you. Okay.
You were able to identify this as a letter that you wrote?
Yes, it looks like the letter I wrote to Mr. Hartman.
All right, is there any doubt in your mind?
I mean, no.
I didn't hear your answer.
I'm sorry, no.
Okay. All right, and is that your signature on the third page?
Yes, it is.
All right. Now, you've told us that the reasons that you recalled for terminating Mr. Hartman's employment and said that those were all you could remember orally. You recall that? I need you to answer yes or no.
Yes.
And I said, is there any document that would refresh your recollection? And my belief is that you were identifying this October 18th, 2016 letter as a document that would refresh your recollection of all of the reasons that you terminated Mr. Hartman.
Yes.
And you have now read it, and is it your testimony that this describes all of the reasons for which you terminated Mr. Hartman's employment 5 days after the October 13th, 2016 incident?
October 18th would be the date that I wrote this letter.
which is 5 days after the October 13th, 2016, isn't it?
Yes,
And 4 days after your investigation began.
yes.
All right. Having now just looked at this, are there any reasons for termination of Mr. Hartman that are not included in this letter?
If he wasn't already previously terminated on the 18th, there would have been some more added on.
And what would those have been?
Operating in his personal vehicle, operating outside the course and scope of his employment of the company, and of course the internal ones, which is he did not give the warrant to Klein-Gear to have it marked up, signed a number, and go to the next investigator up.
Yes, sir. Anything else?
It could have been other things, but not to my recollection sitting here right now.
Now, based on the testimony you've given previously today, you knew about all those things on the date that you wrote the October 18th, 2016 letter, did you not?
I'm sorry, repeat your question.
Based on the testimony you've already given today, you knew about those things you just said would have been added on the date that you wrote this letter, October 18th, 2016, correct?
That's correct, yes.
Okay. But for whatever reason, you chose not to include them in your termination letter to Mr. Hartman.
I was more concerned with the,
What's the basis?
Statement of the letter.
How is it misstated?
Well, it says under 3, I find cause that your actions were outside company policy. So I disagree with your...
Okay, I don't know what I misstated about that, but I mean, Mr. Klein, I'm not arguing that your letter doesn't say that Mr. Hartman's actions were outside company policy. You testified at some length today about those policies, correct?
yes.
What you've just told us is that you did not mention in this termination letter that Mr. Hartman was freelancing.
I believe I didn't clarify it, but I put it in there where he knew I find cause your actions were outside company policy.
Okay. So, you found that Mr. Hartman's actions were outside company policy in a whole bunch of different ways, correct?
Absolutely.
As you've talked about today.
Absolutely.
And so now your testimony is that what is meant in outside company policy also meant that he was working behind your back and cheating your company and doing deals without running the income through your company?
Absolutely.
Okay. And you didn't think that was important enough to mention specifically?
I felt at the time the violations of 1702 were so egregious that that was the main precipice to his termination.
So the answer to my question is yes?
Yes.
What kind of insurance does a bounty hunter have to have?
Our interpretation through the state is that you have to have a general liability policy.
Okay. Is it your testimony that no special endorsement for fugitive apprehension coverage is required?
At that time, no.
What does that mean?
Well, my belief is that we had an insurance policy that covered our daily operations, and that's that.
Do we agree that your company has never had a policy of insurance that includes a fugitive apprehension? Do we agree that Klein Investigations has never had a policy with a fugitive apprehension endorsement while Klein Investigations was performing bounty hunting activity?
We disagree.
Okay. Identify what policy contains the fugitive apprehension endorsement.
I don't have the policies in front of me. I don't know.
Okay. Have the policies been produced to my office as requested?
I have no idea sitting here. I would think we produced the declarations page.
Just representing to you, I have not found a policy of insurance that contains a fugitive apprehension endorsement.
I'm not representing that the policy does contain that, but
Okay.
I will provide you a complete copy of the policy for this case that was provided to me by the carrier.
Okay, fair enough. I'm only interested in the one that would have been enforced at the
Applicable at
time
this
of this incident.
Yeah, I make no coverage decisions. So if they sent me the policy and says this applies, I will send it to you.
Okay. And,
With the premium redacted would be my only
okay,
redaction.
okay. So if I understood you just a moment ago, Mr. Klein, you disagree with my statement that Klein Investigations has never had a policy of insurance that includes a fugitive apprehension endorsement. Is that
I
correct?
disagree, and the reason for that is every year we have to fill out a sheet that says what we do, types of cases we take, personal protection, that sort of thing, and we submit it to the insurance company, and they submit a bid to us on whether or not they'll take us one or two will take them.
But Philip, y'all aren't communicating. He's asking if that policy...
I can handle it. Thank you. So tell me how that is a basis for your disagreeing with my statement that Klein Investigations has never had fugitive apprehension endorsements in its policy.
Because we have a general liability policy that includes all operations of our business.
All right.
To the best of my recollection, every year we submit what we do, and then they decide whether or not we're going to insure.
Who's they?
The insurance company.
Okay. Do you depend on an agent, insurance agent, to recommend kinds of coverage that you should have?
Yes.
Who is your insurance agent? Or the one that would have been responsible for procuring a policy that would have been in effect on October 13th, 2016?
No, don't answer that question. It's not relevant, nor will it lead to the discovery of admissible evidence. It's also private. It's also an invasion of the other person's right that we're about to put on record. Do you understand my instruction?
I do, sir.
Are you going to refuse to answer my question, Mr. Klein?
I am, sir, at the advice of counsel.
Okay, thank you. You instituted any sort of litigation against your insurance agent for breach of fiduciary duty because he failed to make sure that you had the required kind of insurance? Talking about relative to this case.
I'm sorry.
It's just narrowing the question to
I have not. Okay.
talking about anything relevant to this case.
I have not sued an insurance company.
That was my question, talking about your agent.
Oh, my agent? No, I've never sued an agent or an insurance company.
Okay. You received any communications from the Department of Public Safety or any other state organ informing you that you did not have the necessary insurance to be engaged in bounty hunting?
To my best of my recollection, no.
Is there anybody else that would have a better recollection of whether you've received these documents than you?
Klein-Gear or the Texas Department of Public Safety.
Bounty hunting is kind of can be a dangerous occupation, can it not?
Yes.
Yeah. And since we're just kind of sitting here assuming that everybody in the world knows what this means, because you and I might, can you give us a little explanation of what bounty hunting means?
Well, the procedure is if somebody is arrested, they have the right to get out on bond. When they get out on bond, they are required to go to every court visitation or court hearing. If they don't show up to that court hearing or pay their bond if they're on a payment plan, then that bond can be revoked. If that bond is revoked, the court is notified and the court issues a habeas and a warrant for their arrest. Then that warrant is given to the bail bond company, and then the bail bond company forwards it to either the Southeast Texas Fugitive Task Force, or they can hire a private group to go locate the subject and put them into custody.
Okay. Can you apply that procedure with the specific facts of the case involving Mr. Hartman and Ms. Jakowski?
I can't. I don't know the whole facts of what happened because it was never presented to our firm.
Well, you know that Al Reed bail bonds posted a bond for Ms. Jakowski, don't you?
I have not seen any documentation on it other than what Mr. Hartman threw at me in the meeting.
Okay. Well, that wasn't my question. My question was, you know that Al Reed bail bonds posted a bond for the appearance of Gidget Noel Jakowski, don't you?
I don't know that. I have not seen any documentation towards that, and it'd be inappropriate for me to testify in the court that I knew about the warrant. I don't know about the warrant, other than the warrant that was thrown at me in my office.
Okay. I didn't ask a question about a warrant. I asked about a bond.
Again, I don't know about the bond. I don't work for Al Reed.
Well, you work for Klein Investigations, don't you?
I do.
And Klein Investigations had a contract with Al Reed.
Yes, we did.
And there was a considerable difficulty as a result of what Mr. Hartman did in this case, wasn't there?
I don't know about a difficulty.
Let me clarify that. There was an incident involving guns being pointed. Mr. Hartman was arrested and later criminally convicted for what he did. And you're telling the ladies and gentlemen of the jury that in the over 3 years since this happened, you have not bothered to find out whether Al Reed posted a bond?
Again, no.
Okay. Assuming that Al Reed posted a bond, what would have been the procedure that would have resulted in Mr. Hartman attempting to arrest Ms. Jakowski?
So as I've previously testified, Al Reed would send over the paper to Klein-Gear. Klein-Gear would form a file. Once the file is formed, she would do a background on the subject, see where he lives, her family, that sort of thing. And then she would call the Jefferson County Sheriff's Department to verify the warrant.
And assuming all of that was done and the warrant was verified and it was still active, then what?
Then it would be assigned to the next investigator up.
Who would then do what?
They would get the file, they would review the file, and they would try to execute the warrant.
And what does that mean for lay people when you say execute the warrant?
That means you would go out, you would locate the subject, advise them they have a warrant for their arrest, take them into custody, and place them in the county jail. And let me clarify
yes, sir.
that, the nearest county jail. So if they're in Orange County, they have a Jefferson County warrant, you would take them to the Orange County jail.
What went wrong in Mr. Hartman's attempt to do this, other than what you've already told us about his not having followed internal company procedures?
We have no idea how he got the warrant.
Okay. Well, let me ask a more specific question. Do you think it's proper for a person executing a warrant to point a gun at someone else while the two cars are driving down the street?
Absolutely not.
Okay. And you would have never knowingly allowed an employee of Klein Investigations to do that?
Absolutely not. They would not. They are not permitted to do that. They're not police officers. They cannot pull people over. They should not pull their weapon unless they feel their life's in danger.
And how does your employee know that what the correct procedure is
They're trained.
before you send him out into the field?
They're trained fully.
Would another way to say that be that you tell them that?
No, they've studied 1702 of the Texas Code, Texas Department of Public Safety's governing statute, and they know it.
And you're referring to Texas Occupations Code 1702, are you not?
Yes, sir.
So let me just turn that around and see if I can ask the question differently. Is it your testimony that you would have not ever told Mr. Hartman or other Klein Investigations employees that they should not be waving guns around at other passengers and drivers in cars moving down a road or freeway?
Absolutely. No one is permitted to do that.
Yep.
Not even police officers.
But you never told Mr. Hartman not to do that.
Yes, in his training, he knows not to do that. He knows that's against the law.
That's not my question. My question is about you. You never told Mr. Hartman that he ought not to be pointing guns at other people from his car driving down the freeway at some driver in another car. Is that right?
To the best of my recollection, I remember training him 2 or 3 times on proper procedure on handguns. Handgun safety is very, very important to us.
Objection non-responsive. Could you just answer the question I asked?
Go ahead.
It's the one I've asked twice already. I'll try one more time. Is it your testimony that you did not personally tell Mr. Hartman ever that he should not be pointing guns at people on whom he was attempting to execute a warrant as they drove down the highway in their 2 respective cars?
And my answer to you is, to the best of my recollection, I can remember training sessions where that was discussed.
Training sessions involving Mr. Hartman?
Yes.
Okay. I thought you told us earlier that the training about gun handling was done by someone else.
We do continuing education. We also have managers' meetings and employee meetings where we discuss handgun and handgun safety. It's part of our routine.
Is it your belief that Mr. Hartman thought that he was absolutely entitled to point a gun at another driver in a car because he was executing a warrant?
I can't answer that question because you're asking me to get in the head of Mr. Hartman.
No, I was asking you to get into your own head. My question is about what you believed. You can answer.
Ask the question again, please.
Do you believe that Mr. Hartman thought he was perfectly entitled to point a gun as he was driving down the road at another driver in another car simply because he was attempting to execute a warrant as a bounty hunter?
I can't answer your question because you're asking me to get in Mr. Hartman's mind. My mind is you don't pull a weapon on anyone unless you've got a weapon pulled on you or you're under fire.
Okay, that's the 3rd time you've given the same answer and it's not responsive to my question, so I have to object as non-responsive. My question is, do you believe that Mr. Hartman thought he was entitled to do what he did to the two women on October 13th, 2016?
He did it, so I'd have to say yes, that in his mind, he was thinking he had the right to do that.
Did he ever tell you that he thought he had the right to do that?
No.
Did he ever express surprise that he did not have the right to do that?
No. To the best of my recollection, no, to either of your questions.
Did you ever ask him if he thought he had the right to do that?
I don't recall.
Did you know that Mr. Hartman had pointed a gun at two women in a car when you were having your one and only meeting with Mr. Hartman on October 14th, 2016?
When I had the meeting with Mr. Hartman, I did not have all the facts from the Port Arthur Police Department or the Groves Police Department. So there was a lot of surprises that happened over the next 4 days.
Objection non-responsive. Mr. Klein, my question was not, did you have all the facts? My question was, did you know that Mr. Hartman had, in fact, pointed a gun out of his car at two women driving in another car down the road on October 13th, 2016?
The answer is no, I did not know. The only thing Mr. Gaspard, I believe, was the officer I talked to that night in the detective division, had said that a gun had been pulled. I didn't know all the details of going down Twin City Highway or whether or not they were in a car or what was going on. I didn't discover that till 4 days, in the 4-day period that I was investigating.
Did the officer, whether his name is Gaspard or somebody else, did the officer tell you that there was a charge against Mr. Hartman of deadly conduct?
He said that he had been arrested. He did not know what the charges were. To the best of my recollection, that's what he told me at the time. He said there was an incident with a gun and then that he had been arrested.
All he said was there was an incident with a gun?
Yes.
And you didn't ask any further questions about that?
I did. I said, if you know something further, let me know. And he said, I'll try to get you the PC as soon as they check in at the jail.
And for people that don't know what a PC is, what are you talking about?
Probable cause affidavit.
Which is something that would be completed by an arresting officer.
Yes, sir.
I thought you told us earlier today, perhaps I'm not remembering it correctly, that part of the reason you fired Mr. Hartman on October 14, 2016 was because of what you learned in your conversation with the Port Arthur Police Department Detective Division who might have been Officer Gaspard. Did I not state that correctly?
You did not. Okay. On October 18th, Mr. Hartman was terminated. Mr. Hartman was put on suspension on the 14th. The reason he was put on suspension is because he was arrested and we needed time to figure out what the real story was.
Okay. That be a normal procedure for your office?
Absolutely.
If he had been arrested for the murder of John F. Kennedy, would you have reacted in the same way?
Absolutely.
Okay. So, I think I distracted myself with something else, but I had asked you a question and my question was, bounty hunting can sometimes be a dangerous occupation, and I think you agreed with me, is that right?
Absolutely.
All right. How can it be dangerous?
You can get shot, you can get beat up, you can get, there's a bunch of, it's just like being a police officer on the street. When you try to arrest somebody, they don't like it, they usually end up fighting.
Do bounty hunters always carry guns?
I do not carry my weapon. I can only speak for me. There are other bounty hunters in the state of Texas that do carry their weapons. if they're PPO.
Did well, we've established Mr. Hartman was a personal protection officer, correct?
Yes.
A level 4, according to you,
Yes.
not level 3.
No.
What is level 3?
Level 3 is a commissioned security officer. When you go through your PPO training, the first set of your training is becoming a commissioned security officer that allows you to carry a weapon in the state of Texas while on duty. A level 4 is
Go ahead.
a level 4 is a specialized operation as a personal protection officer. That's where you get to protect the body of another individual, and you go through an extensive training in that.
I'm directing your attention to page 2 of Exhibit 1 that you looked at earlier today. This is your letter to Mr. Hartman terminating him on October 18, 2016. I'm confused about why in item number 4 on page 2 you refer to a level 3 personal protection officer.
Yes, sir. So at that time, he was not operating whatsoever under my company license as a level 3 security guard or a personal protection officer. He was not protecting property or an individual.
What I'm confused about is why is that relevant, since you say that he had to be a level 4 to be a bounty hunter?
No, I didn't say that. That was not my testimony. My testimony is that as a private investigator, you can be a bounty hunter. You do not have to be a level 3 or level 4. You can carry a weapon if you are in the process of protecting another bounty hunter, or you're in the course and scope of your duties as protecting a family or whatever comes out if there's a warrant for their arrest. He admitted to me, if you don't mind me quoting what I wrote.
Please.
You admit to me and to law enforcement on video that your intent was to pull your weapon to force the female subject driving the auto to stop her car so you could effect a lawful arrest of the passenger. That is so far against my company policies and my firm and the state law that it's so far outside the bounds of reality and what we do. No one should sanction that.
So when he made that admission to you, did you just sit there quietly and then change the subject, or did you say, why did you think you had the right to do that?
I told him to stop talking, that we needed to initiate an investigation at that point, that he's admitting to violations of state law, and that he was immediately on suspension.
And did he express any surprise with that result?
Like I told you earlier, he started yelling and screaming.
He became irate.
Yes.
Well, that was your testimony.
I think his main concern was his wife and children. How am I supposed to make a living? What are you doing to me? That sort of thing.
And yet you never discussed with him and didn't ask him if he thought he had the right to do what you have now read for us in his termination letter. He admitted to you that he did.
I think I said to him, to the best of my recollection, I remember saying to him, Steve, what are you thinking? You know the rules. You've been trained. You're a level 4. You know the laws of the state of Texas. Why would you do that?
What did he say?
He didn't answer me. He was just talking about, he kept repeating about what am I going to do with, how am I going to provide a living for my wife and my 2 children.
Well, so now we can, now we can actually answer the question from before that you didn't want to answer because you said it was getting inside of Hartman's head. You actually have told us you know that he thought it was okay to do that because he admitted it to you.
Well, obviously.
All right. Okay.
He admitted he did it
Okay.
from a personal vehicle. He wasn't even using a company vehicle.
Yes, sir. Do you have any more information on that?
Talking to me?
Yes, sir.
Information on what?
Why he was not using a company vehicle?
I have no other information.
You never asked about it?
No.
Never part of your investigation?
Yes.
It was part of your investigation?
Just yes or no. Was he using a company vehicle? We were trying to establish, after we found out we did not have a case number, we were trying to establish what in the heck was really going on. Why didn't he pull a number? Why didn't he turn the information over to Klein-Gear? How did he get it rather than Klein-Gear getting it? and establishing a file, verifying the warrant, and doing the background on the subject. We were just flabbergasted that there was such a breakdown in the system.
Understood. So you've already told us this is the one and only time that you've ever discovered where Hartman was, I'm going to say freelancing again, some people would say moonlighting, right?
Moonlighting, freelancing, that would be good terms.
On any of the bounty hunting jobs where the proper company procedures were followed, did Mr. Hartman use his personal vehicle?
To the best of my knowledge, no.
Would you ever know that?
You know, I don't know how much freelancing was going on out there, and I never investigated to find out how much was going on there. One was enough for me.
Yes, sir. That wasn't my question. I'm talking about the non-freelancing bounty hunting jobs.
I've never known Steve to use his own personal vehicle for company operations. Never.
How about other employees?
No.
All other employees have a company vehicle?
Yes, they do.
Okay. So it sounds like you would agree with me that it would be foreseeable if someone did things like Mr. Hartman did on October 13th, 2016, someone might be injured or killed.
I don't know that it's foreseeable. Is it a chance that it could happen? Yes.
Well, you have a policy and there is law that says you don't pull your gun on people driving down the road. Are you able to conclude from that the reason for such a policy is because it's dangerous?
Absolutely.
Yeah. So it would certainly be foreseeable that if someone didn't follow your rules and policies in the law, that people could be injured or killed.
I mean, could be, yes.
You would agree with me that it was part of the duties of Mr. Hartman working for you that he engaged in bounty hunting.
It's part of it. If he gets that assignment, he gets a lot of assignments. But yes, I mean, I guess I'd have to answer yes.
Yes, you're not taking the position that he was supposed to be cleaning the restrooms and instead got a gun and went out and looked for people with warrants.
Well, no, I'm not representing that at all.
Right. So I understand what your position is with respect to this one incident on October 13th, 2016, that Mr. Hartman was not driving his company car and wasn't acting in accordance with your company policies. You've made that clear. My question now is a little bit different. You would not disagree that it was often a part of Mr. Hartman's duties to be engaged in bounty hunting for your company.
That was part of his caseload, yes.
Okay. So regardless of the fact that Mr. Hartman may have behaved improperly here, it would have been part of his duties, and it would have stemmed directly from his engagement in bounty hunting, that he wound up on October 13th, 2016, pointing a gun at two women in a car and pulling them over and attempting to arrest them. He just didn't do it right.
If he had been assigned a case, yeah. He was never assigned a case from our company.
Understand? When is the last time you talked to Mr. Hartman?
The day he was in my office,
October 14th, 2016.
if that's the date.
He did not continue to work for you in some other capacity.
Absolutely not.
He's never worked for you as an independent contractor or doing anything else for Klein Investigations since
Absolutely not.
He has never worked for you or continued to perform any other services, whether as an independent contractor or an employee for Klein Investigations since October 14th,
He has
2016.
not been employed by my company. I've not paid him any money. And I apologize for talking over you.
It happens. We get enthusiastic. Can you tell me what a mandated reporter is?
Mandated reporter?
Yes, sir.
Mandated reporter is that if you are a commissioned officer in Texas on level 3 or level 4, and you witness a crime or you witness or you, during the course and scope of your investigation, you find that there is probable cause for a felony or a misdemeanor crime, you are mandated to report it.
Do you occasionally perform case searches on lawyers?
I don't understand.
Well, I kind of don't either. That was a term you used. Let me try it a different way. It's not that unusual for people to do a little bit of oppo research on an opposing counsel. Have you ever done that on me?
To the best of my recollection, no. I mean, I've read some of your briefs. I've read some of your Supreme Court briefs,
Do you
that
like 'em?
sort of thing. They were very well written.
Always fishing for compliments. Have you ever told anybody that you performed a case search that revealed certain things about my clients?
You know, to the best of my recollection, I can't remember ever saying that.
To the best of your recollection, have you ever performed a case search like what I'm describing?
If it includes the Texas Supreme Court or a brief on the Supreme Court or the TCPA, which I never have understood, never will understand, and trying to educate myself and learn, there's a possibility I could have done it then.
Would anybody in your office other than you have performed a case search on me?
I don't know of anybody that would have. Ms. Gear may have done it on my orders, like I said, a Supreme Court search or something to that effect. In our attempt to educate ourselves on TCPA and what that really is and what it means, and but that's the only thing that I can remember at this point.
Whether you performed such a case search, and I understand that you're not saying you remember one way or the other on this, but whether you performed such a case search or someone else in your office performed such a case search on me, would this have resulted in the creation of a file or some documents?
We do have a file on you.
Okay, is the answer to my question yes?
Answer to your question is, if you're asking if you have a file, if I have a file on you, the answer is absolutely yes.
No, you're rewording my question. My question is, in your file on me, would I find a case search if one had ever been done?
If it had to do with the TCPA, probably.
Okay. What if it had to do with the identities of my clients?
The identities of your clients?
Yes, sir.
I don't know what that means.
All right. Oh, I'll see if I can clarify.
Are you referring to the Operation Klein Watch from back in 2010, 11,
No, I
12?
wasn't, but if you have something to say about it, I'm happy to hear it.
I mean, there was a bunch of pleadings done by John Morgan, and I think we have a file in a warehouse on it, but I don't. That's the only one I can think of sitting here today.
How many times have you written personal letters to the courts of appeal, the justices of the courts of appeals, where a case you were interested in that I was handling was pending?
I'd have to go back and think about it. I think there was one, maybe two, where I was trying to formulate the opinion on the TCPA. But directly to answer your question, I don't recall how many.
I've marked as Exhibit 2 an affidavit that it appears you signed. It says you signed it on March 26, 2015. I'm about to hand it to you so you can,
2015?
yes, sir. Directing your attention to paragraph 21.
I read it. 21? I thought it was 20.
21.
21, I'm sorry.
There's a sentence that begins, in a case search, it was found. Could you read that sentence for us?
I'm sorry, Jeff. Where are you
In
looking?
paragraph 21, it's about the next to the last sentence.
Okay. Let me read the whole sentence.
Yes, sir.
On or about March 16, 2015, a research assistant in our office advised me that in a routine search of Jeffrey Durrell and Thomas Retzloff, that a relationship between attorney Durrell and citizen Retzloff is established.
Since you decided to read that sentence, let me ask you what that means.
A research assistant found you and the other guy had a relationship.
What does that mean?
Again, I don't know. Let me finish and let's see what we can get. Furthermore, Mr. Retzloff is in numerous postings and letters as well as emails, is seen posting emails with threats being copied to Mr. Durrell. In a case search, it was found Mr. Durrell represents Mr. Retzloff against James McGivney of Tarrant County, Texas. Mr. Morgan represented Mr. Givney and his company for a very short period of time in this lawsuit.
Okay. Now are you able to tell me what relationship means when you use it? You typed this affidavit, did you not, sir?
I think one of my staff did.
Is this your signature on it?
Yes, it is.
Did you read it before you signed it?
Yes.
Is it true?
To the best of my knowledge, it is true.
Well, you represented, not to the best of your knowledge, you represented in this affidavit that you had personal knowledge and that these facts were true and correct, did you not?
What's this to? This is to the State Bar of Texas.
Objection non-responsive. Could you just answer my question, please, Mr. Klein?
Ask your question again, please.
This is an affidavit, it's sworn, just like you're sworn to tell the truth here today, correct?
Yes, sir.
Did you tell the truth in this affidavit?
To the best of my knowledge, at the time, yes, I did. But what does this have to do with Peshoff and...
Well, I don't answer the questions here, Mr. Klein, I just ask them.
Okay.
Your credibility is an issue because you're a witness here, and I have the right to ask questions about your credibility.
Absolutely.
You say, in a case search, it was found that Mr. Dorrell represents Mr. Retzloff against Mr. James McGibney in Tarrant County, Texas. Please describe this case search that revealed this on March 26, 2015.
I think you had signed some pleadings or something, to the best of my knowledge, at the time. It's 4 years ago. I don't remember entirely, but if I wrote it, it's true.
So we would find some document of a case search in your office in the file that you have on me.
Either that or Mr. Retzloff had posted it on his website.
Okay. Well, that wouldn't be a case search, would it?
Well, your name search is a case search. I'm sure they did.
Well, isn't a case search of an attorney a search of the cases the attorney represents someone? That's what this sentence says.
Yes, a case search would be anything on the internet that has to do with you or your filings or your suggested filings or your representation of anybody.
Do you know today that I had never represented Mr. Retzloff as of the date you made this representation under oath on March 26, 2015?
Well, that's not according to Mr. Retzloff. Mr. Retzloff says you've been a part of his genre, let's call it, or let's call it relationship that you two have had for many years.
Objection non-responsive. That's not the question that I asked Mr. Klein. My question is, do you still sit here today and testify under oath that you performed a case search that showed that I had represented James McGibney in Tarrant County, Texas in
James
2015?
McGibney?
That's what it says. I'm sorry, represented Retzloff against James McGibney. I misspoke.
Okay.
Let me start.
If I
over.
wrote it then, there was evidence that was given to me at the time.
And I want to know what this evidence is and whether it exists in paper form.
That was 4 years ago, sir, and you know what? I think our interest back then was a little bit more trying to think of a word. Hang on. Our interest back then was a little bit more intense than it is today. Today we could care less.
I don't know what that means. Did you send this affidavit to the Chief Justice of the Ninth Court of Appeals in Beaumont, Texas in 2015 while a case was pending there where I represented Cheryl Johnson Todd against John Morgan?
I don't recall doing that, but if they've got it, I sent it.
Handing you what I've marked as exhibit number 3. This appears to be a fax from the Ninth Court of Appeals to you, returning your affidavit in which you made this claim and asking you to stop making ex parte communications to the court. You remember receiving this from the Court of Appeals?
I don't recall receiving this, but if I did, I did.
Well, is this your letter that dated September 16th, 2015? That'll be the fourth page of the exhibit. To the Honorable Chief Justice Steve McKiffin. And you say, Dear Justice McKiffin, as a mandated reporter in Texas, please take notice of the attached affidavit filed this hour with the United States Department of Justice and the FBI. This your signature on this letter?
Yes, it is.
You sent this letter to Chief Justice McKiffin?
I would have to say yes if that's what it says. No, there's... Yeah. Yes, that was sent because of Thomas Retzloff's email to myself.
How many different courts and judges have you claimed that I represented Mr. Retzloff to?
I don't know.
So many you can't even remember
I
how many?
didn't say that, Mr. Durrell. Now, you know better than that. I just said I don't know.
You've never performed any case search that showed that I represented Thomas Retzloff in 2015, did you?
Yes, we did.
You just claimed you did in a letter to the Chief Justice in an attempt to
And we did.
influence that court against my client, did you not?
No, sir. Actually, it was due to a threat, and if you'd like me to read the threat into the record, I'd be glad to do it. But you and Mr. Retzloff have executed a campaign of terrorism to our firm, my family, and I'm a mandated reporter on this, and he threatened my life in here, and I felt that it was important that they know.
Objection, non-responsive. We take about 5 minutes.
Sure.
It is my intention to finish and not take a lunch break and come back.
We're here at your leisure. Okay.
Well,
Off the record.
that doesn't mean somebody else may not want to.
Back on the record at 12:40.
Mr. Klein, we're back on the record after a short break. You took a chance to speak with your attorney during the break
We did speak.
without telling me anything you might have discussed as a result of that conversation. Do you want to change any of the testimony you've previously given?
No.
Handing you what has been marked as Defendant Klein Investments. I'm sorry, scratch that. Handing you what has been marked as Exhibit Number 4. And is a document entitled Defendant Klein Investments First Amended Answer. In this case, I wonder if you are familiar with this document.
I am not.
You've never seen it before?
Have not. I may have, but I'm not familiar with it.
Would you turn to page 2 of it? This is in a section that's captioned affirmative defenses. I'm going to start at the top of page 2. Are you there?
Page 2?
Yes, sir.
Okay.
Sorry, I didn't mean to rush you.
That's okay.
For further answer, if same be necessary, plaintiff's alleged injuries and damages, if any, were caused by a new and independent cause and were not caused by any act or omission on the part of the defendant. I will represent to you that in this document, the defendant is referring to your company, Klein Investigations.
Yes, sir.
Is that your position in this lawsuit?
Yeah, we didn't know anything about it until I got the phone call that night.
Okay, not my question. Objection non-responsive. What I want you to do is describe the new and independent cause.
I'd have to refer you to counsel.
Well, it's your deposition, Mr. Klein. It's the only time I get a chance to ask you questions about the facts in the case. So I want to know if you know any facts that you're going to be testifying to at trial about a new and independent cause.
Well, I thought he just told you that.
Object to the sidebar. That waives objection. Please answer my question, Mr. Klein.
No, he already answered it. He just told you.
You're making speaking objections and interfering with this examination, which is improper under Rule 199. And if necessary, I will adjourn the deposition and get a court order for you to stop doing that.
I hear what you just
Okay.
said. But you're also asking him the same question he's already answered.
You're continuing to argue with me. Your contribution is limited to objection form or to instruct the witness not to answer, not to yell out comments on my questions like this is an auction and you're making bids.
I'm not yelling.
Okay. Mr. Klein, can we go back to the examination now? I want to know if you know any facts about a new and independent cause of the damages to Litisha Peshoff, other than the ones that are alleged in this case.
I'm not familiar with this document.
Not my question. I didn't ask you if you were familiar with this
The answer would
document.
have to be no,
Excellent.
because I don't know about this document and I'm confused on the legal language.
Okay, well, I'm not, let's clear up the confusion on legal language. I mean, this is really kind of just English. New and independent cause. This is referring to some new and independent, and I don't know what this is. I'm asking you. Some new and independent cause of plaintiff Litisha Peshoff's damages other than what Litisha Peshoff has sued you for in this lawsuit, and I want to know what those are if you know.
I don't
Object
know.
to form.
I don't know. I don't understand your legal language. I don't understand it.
What legal language do you not understand?
I don't understand new and independent cause. This is the first time I've seen this document. I don't know. I'd have to see it in the whole context.
Okay, objection non-responsive. Do you understand the English word new?
Of course I know the name, the word new.
Okay. Is English your first language, Mr. Klein?
Yes, Jeff, it is.
Do you speak, read, and write English?
Yes, Jeff, I
reasonably-
do.
Do you speak, read, and write English reasonably fluently?
Yes, Jeff.
Okay. So what do you think the word new means?
It means new.
Okay, can you give me a definition of new that doesn't use the word new?
What?
You say you don't understand new and independent cause.
I
So
didn't say that.
Yeah,
What I said is
okay.
I don't understand the context of the legal language that it's put into. I understand what new means and I understand what independent means, but I don't understand it as you're picking out 3 words in the middle of 2 paragraphs, and I don't understand the legal context. I'm not trying to trick you. I'm not trying to fool you. I'm just telling you. I don't understand.
Mr. Klein, I understand that you're not an attorney. I am not asking you anything about legal context. I'm asking you about the 4 English words here that say new and independent cause. Your pleadings in this lawsuit say that my client's damages were caused by some new and independent cause. I want to know what you're going to tell the ladies and gentlemen of the jury this was.
Object to form.
My answer is I don't know. Just don't know.
So put another way, then, you do not know any facts that you can testify about today that would describe some new and independent cause of Litisha Peshoff's damages in this lawsuit, other than what Stephen Hartman did to her on October 13th, 2016.
I don't even know what Stephen Hartman did to her, other than what I've read.
Okay, not the answer to my question. Objection non-responsive. If you plan to testify to facts about a new and independent cause of Litisha Peshoff's damages, this is my only chance to find out what those facts are. If you don't tell me, then I am going to object to your attempt to testify to them at a trial. Do you understand?
I understand.
Are you going to tell me, if you know, facts surrounding an alleged new and independent cause of Litisha Peshoff's damages?
For the fifth time, I don't. I don't understand that phrase, and I don't have anything new or independent that I know of sitting here today.
Okay. So you're not able to tell me about any facts of a new and independent cause of Litisha Peshoff's damages?
Sitting here today, no, I do not.
All right. Going to the next paragraph. Take a moment to read that.
Okay.
The word defendant here again is referring to your company, Klein Investigations or Klein Investments. This says that you are going to show that the incurrence in question, and that's Mr. Hartman's arrest of Litisha Peshoff, was caused by acts and omissions of a third party over whom Klein Investigations has no control. Can you tell me, but first of all, do you understand those English words?
Yes, Jeff, I understand the English words.
Will you please tell me who this third party is, or who these third parties are who caused Litisha Peshoff's damages over whom Klein Investigations had no control?
Stephen Hartman
Okay.
would be my guess.
I don't need a guess. I need testimony.
My interpretation of this paragraph is Stephen Hartman.
All right. So your testimony then today is that Klein Investigations had no control over Stephen Hartman.
At that point in time, we had no control over him, yes.
Well, what does at that point in time mean?
When the incident occurred.
Well, you mean at the day and the hour?
That would be my guess, yes.
Okay. So your legal position is that you can't be liable for something if in the 10 minutes that Mr. Hartman was doing something you couldn't see, you didn't control it. Is that your position?
Objective form.
My position has been, and will continue to be, is that Stephen Hartman was not working or using any Klein investments or investigations, as you put it, equipment. He was not on our time clock. He was using his own personal vehicle, and that he was a third party working outside the course and scope of his employment.
Yes, sir. Objection non-responsive. Let's see if we can make this simpler. Your testimony today is that the words "a third party" in the second paragraph of page 2 of your answer refers to Stephen Hartman. Is that correct?
Yes.
And there are no other third parties that would have caused those Peshoff's damages that you are prepared to testify about today?
Yes. There are no other third parties.
My recollection was that you testified earlier today that when you learned of the October 13th, 2016 incident between Mr. Hartman and Ms. Peshoff, you were in your office on the phone? Is that right?
That's not what I testified to. I said I was at a function in Winnie, Texas, out on a ranch.
Okay, fine. I didn't hear any of that. Who knows why? Who is H. Mark Burke?
Doesn't ring a bell with me.
Handing you what we've marked as exhibit number 5. I believe this to be a letter written by you. If you could take a glance at it and tell me if this refreshes your recollection and if this is your signature on the second page of it.
This is from January 2015. The letter is mine. I did sign it. May I read it for a minute?
Yeah, of course.
Thank you. I think that I sent this letter to Mr. Burke, who is the managing partner, because of your constant harassment and threats of lawsuit, and Mr. Retzloff's constant threats, and I was working with, that's when Mr. Espy, who was my insurance attorney on another case you filed on me, was scared out of the case because his family's life was threatened by Mr. Retzloff. And that spun up an investigation with the State Bar, U.S. Department of Justice, Jefferson County, of you and Mr. Retzloff, again, after my life was threatened again, and constant harassment with lawsuits.
Objection non-responsive.
Objection non-responsive to the tirade.
Your letter and your signature.
It is my letter and my signature.
Where did you get the idea that H. Mark Burke was the managing partner of Hansel LaPorte?
I have no idea.
This is not the first time you've written letters to somebody you thought was the managing partner of a firm that I worked for, is it, sir?
I don't remember.
Do you recall writing a letter to somebody named Juan Cruz when I was at the law firm of Escamilla, Ponick and Cruz?
I don't remember.
You also described him as the managing partner.
Again, I don't remember.
Well, here's the point of that. Neither Juan Cruz nor H. Mark Burke was the managing partner of the firms that you were writing to. In fact, both of them were organizational inferiors to me. The only thing I can find that would be a reason you would think this person was the managing partner is that he appears first on the website. But that's because alphabetically Burke is before the other names in the firm. It's also the same with Juan Cruz. My question is this: are your investigating skills so weak that you're not able to determine who the managing partner is when you decide to write a letter to my firm and assassinate my character?
And you don't need to answer that question. Instruct the witness not to answer. It has no relevance to this case, nor will it lead to discovery of admissible evidence. It's purely for harassment.
Are you going to follow your attorney's instructions? Mr.
I
Klein?
am. Say again?
I can hear that. Are you wasn't quiet?
No. Is that better?
No, you're fine.
Okay.
Something was rubbing on the cord. I can hear it.
Okay.
Were you in the Dominican Republic earlier this year, Mr. Klein?
Object to the form of the question. Instruct the witness not to answer. It's not relevant to any issue in this case, nor will it lead to the discovery of admissible evidence in this case. Do you understand my instructions?
I understand your instructions.
Now waive that objection because I didn't ask you for a basis for it, and by giving an argumentative speech about why he shouldn't answer, you've now waived objection to it. So, Mr. Klein, I'm going to have to now require you to answer it.
No, he's not answering the question.
Are you going to follow your attorney's instructions?
I am, Mr. Drell.
Are you going to follow your attorney's instructions to refuse to answer a question as to which all objections have now been waived?
You and I disagree on that.
I don't care. Stop interrupting my examination.
I'm entitled to protect
You're
my
not
client.
entitled to give speeches and make arguments during my deposition. You can do that to a jury.
Witness
I
is
just
still
need-
instructed
I just
not
need-
to answer the question.
Okay, how many more times are you going to say that?
I don't know what other questions you're going to ask.
Okay, my question is, are you going to follow your attorney's instruction and refuse to answer my question as to which all objections have been waived?
I answered that. My answer is yes.
Okay. Can you tell us how many other bail bond companies you've done bounty hunting for besides Al Reed?
Can I consult with my attorney?
No.
He always has the right to consult with
He
his
does not
attorney.
have a right to consult with you except to assert a privilege.
That's what.
Are you claiming that this is privileged?
Yes.
All right, then you get to consult with your attorney. I don't know how the hell it can be privileged.
Back on the record at 104.
Back on the record after a break that you requested, Mr. Klein, to discuss whether to assert a privilege in refusing to answer my last question. Are you now ready for us to proceed?
Yes. Ask your question, please.
Okay, thank you. What other bail bond companies have you done bounty hunting work for besides Al Reed?
Object to the form of the question and instruct the witness not to answer based on privilege.
What privilege?
Privacy privilege?
The privacy privilege?
Yes, sir. But that wasn't the question you asked earlier.
I'm aware of that.
Okay.
How many other bail bond companies have you done bounty hunting work for besides Al Reed?
I'd have to say 10 or more.
But not in the last 2 or 3 years?
I hate to put a date on it. I think it's probably been 2 or 3 years. That would be fair.
And the 10 or more companies that you were doing bounty hunting work for were in that 13-year period you told us earlier.
It would be more than 13 years. It would be since 1994, so what would that be? 10, 20, 20 years, 20 some
I
odd
don't
years.
know. Thank you. So 10 or more companies over 20 years that you did bounty hunting work for, but you just don't do it anymore.
Yes, we've moved on to other things.
Okay, why don't you want to tell me what other bail bond companies you've done work for?
Privacy agreements. Oh, sorry.
What does
Because he has-
what does that mean?
Go ahead.
I'm sorry. Under 1702 of the Texas Code, we have a right to withhold our clients' names.
Well, first of all, there's no such thing as the Texas Code, and second of all, it's not what you just said. You said you had a privacy agreement.
Signature of privacy agreement contracts, and number 2 is that under the Privacy Act, we have a right to withhold names.
What is the Privacy Act,
It's a federal and state act in Texas and the federal government.
and what does it say?
Says that it's confidential.
That what's confidential?
Our client list.
All right. You would not be doing any business with any of these companies today because you don't do bounty hunting work anymore, right?
We may do
Check the
business.
form.
Okay.
You still have to answer.
I understand. We may do business in other natures.
In other what?
In other cases.
I don't know what that means.
What that means is we might have other cases besides bounty hunting that we work with those certain clients with.
How many other instances have there been involving force or threat of force when you or some employee of Klein Investigations was apprehending, arresting, or otherwise picking up a bounty defendant?
I lost you in the first sentence. Go ahead and try again.
Has this ever happened before?
Whatever happened before?
What happened between Mr. Hartman and Ms. Peshoff?
No, it's never happened before.
Have there ever been any complaints filed against you saying that it happened?
To the best of my recollection, no. I do recall one complaint that was filed by Thomas Retzloff on your firm's behalf, is my belief.
Why do you think that what Mr. Retzloff does is on my firm's behalf?
Because that's what he says
Where does he say this?
all over his website, and he sent me emails to that effect.
How do you even know whose website the BV files is?
I think it's been well established that it's Mr. Retzloff's.
Okay, well, just tell me, then good. Then you can explain to me how that became established, because I don't know it.
The Phoenix office of the FBI has a document that was shared with me regarding, I believe there's another Retzloff, I can't remember the kid's name, where he swore under oath in federal court that his father was the operator of the website.
The operator of what website?
Whatever that, what's it called, BV files?
I
think
don't
you
know
just
what it's
said.
called.
Well, you just said it, BV files.
I know of a website called BV Files.
I think it's called ViView, if I remember
I
correctly.
don't remember what it's called. But you're convinced this is operated by Thomas Retzloff, is that right?
Yes.
All right. Have you ever claimed it was operated by anybody else?
I
Check the form.
don't know.
You don't know if you
I can't
claimed?
remember.
Well, that's an odd thing to not remember, Mr. Klein, because if you're firmly convinced, as you just told us under oath you are, that it's operated by Thomas Retzloff, why on earth would you be telling somebody else that it was someone different?
Check the
I don't-
form.
Okay. I don't know to what you refer.
I'm referring to the answer you just gave. You said you don't know if you told anyone else that someone besides Retzloff operated the BV Files blog.
Again,
Objection form.
Again, what?
I don't have an answer for you
Why not?
because I don't know what you're referring to. You're saying that I said something out there to somebody else that somebody else operated the ViView files. That's what you're saying.
I'm not saying it, Mr. Klein. You just said it. I asked you if you had ever told anybody that someone besides Retzloff operated the BV Files blog, and you said, I don't know.
Third time, I don't recall.
Okay. But if you know it's Retzloff, how is it that there are so many possible recipients of your message that it's someone else that you can't even remember how many people it was you told this?
Objection form.
Again, I can only refer back to the FBI, Phoenix, Arizona.
Do you just make up facts as you go, Mr. Klein, to suit whatever situation you're in, like telling the Court of Appeals that you performed a case search that proved I had represented Thomas Retzloff when that wasn't so?
Objection form. Instruct the witness not to answer. Do you understand my instruction?
I understand your instructions. I'm not going to answer.
You didn't perform any such case search, Mr. Klein. You couldn't have because there would be no case search that would show that I ever represented Mr. Retzloff in 2015. You know that today
Objection
or
form.
not?
I do not
Object to
know
the
that
form.
today.
I'll pass the witness.
I'll rule as a trial.
We reserve.